Hello, I'm Bruce Frohnen, professor of law at the Ohio Northern University College of Law and a senior fellow with the Russell Kirk Center for Cultural Renewal. I'd like to give my thanks to Bob Paquette and to everyone at the Alexander Hamilton Institute for inviting me to deliver the 17th annual David Aldrich Nelson Lecture. I'm here to talk about the Constitution and in particular to address the rather basic question, why have a Constitution? What good does it actually provide to us? This is a question that's been asked a fair amount of late. We've been hearing from some quarters that our Constitution is a threat to democracy. And we've been hearing from many quarters that we need to dedicate ourselves and our constitutions to some new or old program of policies in order to live up to its promise. Today, I'd like to argue that all of this is a mistake. Our Constitution is neither a threat to democracy nor a promise for any specific set of policy goals. It's something quite different. Something that's not only worth pursuing, but more basic, more fundamental, and even more important than its critics are demanding from it. It's a structure for self-government under law. A deeply important human achievement we can't maintain unless we recognize and regain certain important virtues in the system and in ourselves. So to begin, Erwin Chemerinsky, the dean of the University of California, Berkeley's Law School, has argued that we should do away with our Constitution. We should replace it because it is a threat to American democracy. This Constitution, he adds, must be replaced with one that is more friendly toward democracy. Now, why is our Constitution a threat? Because it puts checks and limitations on the ability of majorities to put their own policy preferences into law. Chemerinsky criticizes constitutional institutions like the Electoral College, which requires that presidents be chosen by a majority of voters within the states, rather than a simple majority of everyone voting nationwide. In addition, he finds unacceptable legislative mechanisms like the filibuster, which sometimes allows a mere 40 out of 100 senators to block proposed legislation and presidential appointments. And don't get him started on the Supreme Court, when its decisions seem wrong to him. In such instances, it's too powerful and must be brought to democratic heel through greater control by Congress and the president over its membership and even the length of justices' tenure. Chemerinsky's overall point is that the Constitution stands in the way of rule by the people. That said, it's unclear exactly what people he's talking about. I say this because he also opposes requiring that those who seek to vote first show that they're citizens of the United States, the country in which they would vote. If people who are not citizens, people who may be here only temporarily, can help determine how we're ruled, it's unclear who is self-ruling. And if settled laws determining who shall vote are ignored or allowed to be flouted, it's unclear how those who supported these laws are ruling themselves. At least as problematic for the democracy argument, any constitution is, at its very core, a set of rules for making rules. It gives us procedures, for example, that all legislation must pass both houses of Congress, then be presented to the president for possible veto and override. Procedures that tell us what we must recognize as law. This really is an important way to define the rule of law. Only if the people can know what counts as a law can they refuse to obey orders coming from whoever wants to push them around. Whether it's a gang claiming that right from force, or a president who thinks his decrees should be followed without question. So without that rule of law, and without a means of making it real, the people are ruled by force. Not rules, but the power of those who can make the people follow their own orders at any particular time are in charge. And this makes it impossible for people to plan their lives, trust one another, or know what they'll be punished or even killed for doing or failing to do. This is not a free or even a decent life. So if we can't have procedures for making law that are, well, law, then what can we do to make our country more democratic? The only alternative, it seems, would be to figure out what the people want, let's say through polling, and make it a law. That won't work for Chemerinsky, because strong majorities favor policies like requiring photo identification to vote. And Chemerinsky is vigorously opposed to these kinds of rules. What this tells us is that Chemerinsky isn't demanding democracy in the sense of making majority will into law as quickly and efficiently as possible. What he actually wants is to have a set of policies that he likes, and he's pretty explicit about this, put into action, policies that are blocked, he thinks, by the machinery of the Constitution. Now, many people would like Chemerinsky's democratic policies. He's most concerned to use the national government to establish programs that would equalize the life chances of people according to their race, sex, sexual orientation, and sexual identity. So diversity, equity, and inclusion, a more generous welfare state, various government programs redistributing wealth, all these are programs that Chemerinsky supports. But liking these policies, even declaring that they're the only just policies we can possibly have, doesn't make them constitutionally required, doesn't make them what any democratic constitution would require. Now, I'm not saying you can't like these progressive policies. I'm just saying they aren't the stuff of constitutionalism. They're political policies and goals. So it's not just the progressive left that wants to reduce the Constitution to the service of specific policy goals. On the other side of the political spectrum, many who term themselves conservative demand that we read the Constitution as a program to put into action the principles of the Declaration of Independence. These critics claim that our Constitution was instituted to make real in our lives a brief passage from the preamble to the Declaration. That passage asserts truths that are self-evident, among them that we're endowed by our Creator with certain inalienable rights, including life, liberty, and the pursuit of happiness. Now, the result on this view would be a classical liberal regime of limited government aimed primarily at defending property and individual rights against government action. I'm not here to take any position on the self-evident truth of these claims, any more than it's my job today to take a position on the relative wisdom of progressive policy goals. This long prologue is simply intended to show that there are all kinds of conflicting policy goals that people want to read into the Constitution. Both sides of these policy arguments are demanding a Constitution that aims to directly impose their political preferences. Not only is our Constitution not directly aimed at any of these goals, our Constitution seeks to prevent any such policy preferences from undermining a deeper, more important, and properly constitutional goal, namely self-government under law. This is not to say that constitutions have nothing to do with politics or public policy. The policies of our Constitution, in one sense, may be found in its preamble, which states, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America." But this list of good things does not constitute a coherent program of action, something like those of progressivism or classical liberalism. These political goals of the preamble, necessary to make the Union more perfect, don't work together as a plan of political action. To take only one example, to pursue the common defense may very well, if not one is not careful, entail actions, for example, an unpopular military draft or intrusive security laws that interfere with domestic tranquility, as well as the blessings of liberty. The point is that these goods are underdetermined. So underdetermined, in fact, that the only reasonable conclusion is that they're general statements intended to be defined as well as made real through the structures and the procedures set forth in the Constitution itself. That is, the preamble is best understood as a statement that the Constitution aims to provide the means by which the people may govern themselves up to and including determining what shall constitute justice, the blessings of liberty, and other broad terms denoting a healthy political community. So, in concrete terms, the Declaration's only legal effect was to declare the independence of the 13 American colonies from Great Britain. These new states were then joined in a loose league of friendship by the Articles of Confederation. It was only at this point that the Constitution formed these 13 independent states into a more perfect union, joined by a limited federal government with expanded, though limited and enumerated, powers. How does the Constitution do this? By providing the means by which the people may achieve the common defense, ensure domestic tranquility, and so on. So the American Constitution properly is seen as a legal and political instrument designed to achieve, as its terms make clear, a more perfect union, whatever the people may deem that to mean over time. It does so by establishing a government with set powers, limitations, and rules of action. Most importantly, a constitution sets rules for making rules, such that the people, including government officials, can know when to obey an order from one who claims legal authority. But more is involved here. To begin with, if a constitution is to establish self-government, it must somehow ensure that governing is in crucial ways done by the self at issue, namely the people. And what is the people? Sadly, this has been an issue of much debate, conflict, and even violence. In the United States and in the colonies from the earliest times, including in the Mayflower Compact from 1620, communities, churches, colonies, and other groups have claimed the right to rule themselves under the laws of the nation or the empire, or highest of all, of their God. Not all members of these communities were empowered to vote. Even in the democracy of ancient Athens, the vast bulk of residents were enslaved, and only native-born males exercised any political power at all. That said, in a constitutional republic, the people, especially those who can vote, is defined by law. It can change. It can be expanded by law. This happened slowly in the United States, as everywhere. And so now we're at the point where almost every citizen aged 18 and older can vote. And now we see that some want those who aren't citizens or those who are younger than 18 should vote as well. My point is that this issue can be one of continuing controversy. But historically, that controversy has been limited by concerns that those who exercise political power, including the vote, be capable of doing so in a public-spirited fashion. As important, it's been limited by settled, known, and enforced law. The franchise was extended only slowly through and within a constitutional order. Change rarely happens overnight within an ordered system devoted to reasoned deliberation. And reasoned deliberation is what the Constitution was designed to require. Each branch of our government is vested with only limited powers specifically stated in the Constitution as law. And the national government can only reach certain specific issues related to defense, interstate commerce, and the like, by law. The rest, issues of local health and policing, are left to the states and our federal system and to their own law. Even within the branches, there are complications designed to slow down lawmaking and filter out selfish, destructive plans of action. For example, each member of Congress comes from a separate geographically specific district. This means that while the member of Congress may be beholden to some special interest, other members will be beholden to other special interests. The goal, as Publius pointed out in the Federalist Papers, is to have enough of these special interests cancel one another out, that those members who have no dog in the fight, or at least this specific fight, will cast the deciding votes in the public interest. There are many such undemocratic mechanisms in our Constitution, all of them designed to help the people rule themselves. All of them are intended to make sure that bad motives are filtered out, that those who serve in government will carefully consider the effects of their actions on the people as a whole and not just on their friends. So the goal is not a specific set of policies, though some are more helpful than others, but to maintain a system that requires all policies, all laws, to be well considered by people concerned with the public good. The problem with this system is not that it's undemocratic. It's simply a mechanism to make sure there's deliberation, not a specific outcome. The problem with this system is that it can't run on its own forever. People have to follow the rules, or it doesn't matter what rules you've got. Law for self-governing people must be ordered under a constitution that itself has the force of law, if that self-government is to last. Political officials must be answerable to the people. Everyone equally must answer to common laws, including laws concerning who may govern whom, what, when, and how. Otherwise, it's the officials who rule, not the people. So the rule of law can be maintained only if the Constitution itself has the force of law, meaning that its rules, its promulgated rules, are enforced against the governors as well as the governed. To recognize the Constitution as fundamentally a structure and rule book for self-government, then, is to assume a set of rules, structures, priorities, and perhaps most controversially, virtues that are necessary for it to function properly. Why virtues? Because without appropriate habits and values among citizens and governors, constitutionalism and the rule of law are impossible to maintain over time. Their structures will be ignored or undermined repeatedly to such an extent that people no longer can assume they will be followed, and so are no longer obligated or likely to obey them. The most important here is a concept termed constitutional morality. Constitutional morality is the felt duty of government officials, in particular, to abide by the restrictions and the imperatives imposed on them by a constitution. These officials must practice the virtue of law-abidingness within their proper sphere. They have to have the habit of following the law, even if they think that law is stupid, even if it gets in the way of democracy as defined by their own lights. Now, this kind of virtue is not some model of moral perfection, but rather a habit of conduct grounded in a sense of public duty, including, most importantly, the requirements for a good member of Congress, a good Supreme Court justice, a good president, or a good administrator. These specific roles and the virtues that go along with them are held within an overall duty to abide by the Constitution as a whole, particularly forms like the Constitution's separation of powers. This means a member of Congress, president, or Supreme Court justice must defend his turf from aggressive actions from the other branches, but also restrain himself from either overreaching or dumping off his duties, say to an administrative agency. Philip Hamburger has set forth an important related concept of judicial duty that places judges squarely within the reach of constitutional morality. He presents judicial duty as the call to specific constitutional virtues applicable to judges. Currently moribund, this formerly dominant tradition bound judges to decide in accord with the law of the land, which included the Constitution as the highest enacted law, the supreme law of the land, as well as lower statutes and the common law, custom. The virtues called for in a judge were inherent in the office, which was one of independent judgment, an exercise of intellect or understanding, free from any intrusion of will. One hears little of these judicial virtues today. In part, this is because their historical pedigree has been forgotten. Their bases and obligatory nature were assumed before, during, and for over a century after the constitutional ratification debates. Only a few principles of judicial duty, most importantly, the status of the federal Constitution as supreme law of the land, required and received explicit statement. But the duties were spelled out, especially in the oaths taken by incoming judges and in often explicit statements of the responsibilities of judicial office. Such statements were intended to bring the judge's duties to mind within the context of humility and acceptance of the limits of one's own office and its attendant authority, limitation as duty. Like all government officers, judges had a duty to follow the rules and develop the specific virtues assigned to their office within the constitutional orders. When such habits fray, office holders develop the habit of acting arbitrarily, ignoring the separation of powers, doing what they wish, acting arbitrarily. And the people in their turn lose the ability to know what counts as law, and with it, the ability to know and follow law on a regular, habitual basis. This is a problem because the habit of according authority to a pronouncement from the state is necessary if law, rather than mere force, is to rule. Most importantly, the people must understand in a general sense that they're bound to obey the law as a moral duty, rather than merely a practical necessity, a way to stay out of jail. Otherwise, the law itself will lose its efficacy, because the people can't trust that laws will be followed or upheld. And there's simply no point in following something that's called a law if it's not generally followed and enforced. Perhaps worst of all, the people may lose the habit of defending their freedom. If they don't know where laws come from, they may simply follow whatever they're told. They may gain the habit of following whatever crazy order is handed down to them by anyone claiming the right to tell them what to do to deal with some crisis or emergency. Today, of course, legal academics tend to deprecate discussion of this moral and sociological grounding of constitutional legitimacy. One would be hard-pressed to find contemporary references to what Wilmore Kendall and George Carey deemed the essential, basic symbol of the American political tradition, namely that of a virtuous people deliberating under God. That said, it's important not to allow anti-religious bias to blind us here. Normative standards and a hierarchy of law that reaches above and beyond, and thereby shapes and protects the Constitution, play a crucial role in helping us understand how law works, how it binds a people to the government through which they claim to rule themselves. Historically, this was done in a formal constitutional structure and by judges and other officials finding and acting according to the law of the land, including the Constitution. Now, the natural law context within which judicial duty was exercised didn't involve any theocratic code or simple exercise of unbounded conscience. Instead, it involved applying long-established assumptions regarding human rationality and adherence to the historically grounded common good, long embedded in equity and in the common law. The rise of legal realism, the cynical reduction of all law to questions of power, so common in the academy today, has undermined these understandings, and with them both legal virtue and the rule of law. Stuart Banner has shown how Americans' traditional understanding of law was undermined in the United States, especially in the later 19th century. A massive increase in the availability of legal texts, including statutes, and published legal opinions turned lawyers' attention from reason and circumstance to the mere parsing of precedents. In addition, the misuse of natural law arguments for broad policy goals, a misuse of mere abstraction made most obvious later in substantive due process arguments, caused many to dismiss natural law argumentation as mere cover for the political preferences of the one using them. As damaging, the rise of legal realism coincided with the rise of an individualism hostile to intermediary associations. These groups, families, churches, various communities, were the places where people learned to rule themselves in a variety of groups and circumstances. It's also where they inculcated virtues, including self-control, law-abidingness, and the refusal to abide by that which is not law. With all this, self-rule ceased to be a clear value. Judicial duty and constitutional morality came to be no longer generally recognized. Instead, law became a tool by which the state sought to enforce one group or another's prejudices about what kind of life should be imposed on the people. And so the structures of the Constitution were reduced in the minds of those entrusted with their protection and enforcement to mere obstacles to the efficient exercise of power. At about this same time, America developed our current administrative state. This fourth branch of government makes its own laws, insulated from political pressures and the limitations of the Constitution. It's dedicated to the notion of efficiency in the exercise of power toward whatever vague purposes Congress chooses to hand over to it in enabling legislation. First institutionalized by the progressives, made much more real, effective, and broad-based under the Franklin Roosevelt administration, and then later under Johnson's Great Society, it has come to rule the vast bulk of our lives. Why? Because it makes it possible for Congress to reach out further than it could in doing the hard work of drafting detailed, specific, proper legislation. Through enabling legislation, Congress can take credit for addressing important needs, important issues, important problems, without taking the responsibility for the consequences of their laws. So, for example, the legislation that established the Occupational Safety and Health Administration, OSHA, was established, quoting, to assure, so far as is possible, every working man and woman in the nation safe and healthful working conditions, and to preserve human resources. Noble goals, to be sure, if a slight bit broad, but how was this to be accomplished? Through the establishment of standards deemed by the agency, or the Secretary of Labor, appropriate to provide such safe and healthful working conditions. And from where would such standards come? By what statutorily defined methods would executive officers formulate the rules by which people would live? The conditions under which they would work? The conditions under which they might employ others? Either by an in-house advisory committee, or more often, through adoption of a national consensus standard. Now, this standard was defined as whatever had already been adopted by a nationally recognized standards-producing organization under procedures where it can be determined by the Secretary that persons interested and affected by the scope or provisions of the standard have reached substantial agreement on its adoption. That is to say, by cartels, by already powerful corporations seeking to increase barriers to entry and to maintain their own status, power, and financial wealth. So long as those deemed interested have been given the opportunity to participate in the formulation of the standard is deemed appropriate. Obviously, it's not always corporations that are involved. Often it is nonprofit organizations set up specifically to lobby the government and form regulations, particularly in the area of climate change. One might see the OSHA rulemaking formula as a demand for law-like rules in the formation of regulations. But this delegation of power is a recipe for lawmaking by interest group. It includes little or no genuine representation of the interests of the general public, including the general working public, who have neither the time nor the wherewithal to become involved in setting consensus standards because they don't control powerful organizations. The culmination of this methodology in regulation has been the consent decree. That's the name given to bargained agreements between the regulatory agency and the regulated company, without involving specific regulations at all, other than by reference, and with the courts taking at most a passive role. These consent decrees have become increasingly common, including as a tool for making public policy through lawsuits. The government may sue a company not involved in the consent decree, using the standard established in that decree as a means of forcing compliance. Of course, with a consent decree, the regulated company avoids prosecution under terms bargained out with the agency. In effect, Congress doesn't regulate. It enables agencies to make deals with the regulated industries on a case-by-case basis. This is intrinsically unlawlike, especially when these case-by-case ad hoc agreements are then applied throughout an industry. Nothing in the Constitution empowers Congress to delegate its power to make law to an administrative agency, whether it's the IRS, the Securities and Exchange Commission, or OSHA. But that is what agencies do when they draft regulations and make consent decrees that change Americans' rights and duties. The complex of administrative agencies that now make up so much of our government can be seen in structural terms as a system of extra-constitutional conditions built on earlier deviations from constitutional government. Today, most law is not made by Congress, presented to the president for possible veto or override, then overseen by courts that recognize their job is to decide cases under the law. What this means, unfortunately, is that the American people no longer rule themselves. They're no longer self-governing. From a government of limited authority structured to promote and mediate among flourishing associations, our republic has descended into an unpredictable but comprehensive web of powers emanating from a multitude of agencies over which the people have no meaningful control. Law no longer rules. We're no longer governed by rules of general applicability that are consistent, known, and produced according to the rules of the higher law of our Constitution. Instead, we're governed by rules that may or not be applied to us, that may come from Congress, the courts, from the president, and from any of a plethora of administrative agencies. And these quasi-laws may arrive in any of a bewildering variety of forms, from statutes to executive orders, to presidential signing statements, to court decisions, to consent decrees, administrative regulations, agency interpretations of regulations, memos and other administrative actions, and even administrative interpretations of the proper impact of consent decrees. In other words, many steps separated from law. Now, I haven't time to go into all the problems with this confusion of almost laws, but the effect is clear that people don't know what the law is, how to interpret it, or even where to look for it. Such a people is not governing itself. It is, in fact, governed by an absolute power, reminiscent of the early modern regimes, in opposition to which American constitutionalism grew. Over time, such a people will become incapable of governing itself because too many citizens will no longer have the habits, the dispositions, or the values of a self-governing people. Restoring constitutional self-government would entail the recovery of character, of virtue, among the people, such that they would demand adherence to, rather than mastery of, the law. It would also require recovering a structural understanding of the Constitution that gives priority to order and limitations on power, rather than to the drive to use power to remake the world. It would prioritize freedom within natural associations, above any freedom from the various harms and tragedies of life the national government claims it can secure for us. More than anything, it would prioritize self-government over efficient or even effective government, if by effective one means the ability to quickly impose the will of the governors, however derived. Law, then, would be aimed at supporting rather than replacing the more natural associations in which actual persons learn the virtues necessary to self-government. This, after all, is what it means for a people to rule itself under law. This is what it meant historically to live under the Constitution of the United States. Thank you for your attention. Good day.